हो सकता है। वी आर लाइव नाउ।
Okay. Do we have any students yet with us? With us, please check the student count. Hello guys, hello Ravi, hello Pritika. I'll just give us a bit of time so that more students join us. So please in the comments meanwhile tell me. Good evening Tanya.
Hello guys, hello Ravi, hello Pritika.
Good evening, good evening. How are you guys doing? How is Judiciary DJS preparation going on? I would like to know. Good evening Meda. How was the mock test today? How did you hold up? I would like to know while more of us join us here. Any problems we are facing with LLP Act? Anything that you feel like you need brushing up on? Yes, I'm checking the comments. You can let me know over there. Yes, Tanya, would you like to tell me how LLP Act is going? Vikas, can you please text in the DJS group and tell the students that the session is live? They must join now. The DJS group as well as the respective groups. Meda had not attempted the mock. I did it for the first time today, but it seems easy to understand. Yes, it is. Meda, why did you not attempt the mock today? Pritika, did you attempt it? Ravi, is the mock attempted? If you are a student, if you've taken the course. Vishal, please text meanwhile. I'll be starting in a minute, guys. You cannot wait for long. Medha will be attempting after the quiz. Medha, ideally, you should be attempting the marathon, then the mock, and then go into the quiz. That's how it is designed. What it does is that um, it, kind of hones your brain to understand everything, and it's a speedy, it's like a speed check. The quiz here is like a speed check. That's why we have the timer and everything. So the ideal way to do it is the way it has been designed. So please stick to the schedule. That's what will give you the maximum benefit. Yes. Okay, guys. Let's start. We have 9 students here. Means 7. 9 people here, that means 7. So, guys, this is your LLP, Limited Liability Partnership Act 2007. And as Tanya has picked out, it's not a very complex thing to understand. You just need to get the basics of the act right. You just need to get just the basic concomitants right. If you have a good understanding of, I hope you can see my screen. Can everyone see my screen, guys? Just give me a nod in the chat here. All right, perfect. So, guys, here we move on with the LLP Act quiz. And if you've understood the basics of your Companies Act, your Partnership Act, right, this will just be a breeze. It will be cakewalk for you. So, Pratibha, Tanya, everyone, Tanishka, Medha, and we had Ravi at the beginning. There is Pratika. I hope we are all sorted and we can begin with the quiz. So, here is your first question. So, the essence of it, the actual act, what a limited liability partnership is, a very conceptual question. A limited liability partnership is A, not a separate entity from that of its partners, B, a legal entity that is separate from that of its partners, 3, it is a body corporate, 4, only B and C are correct. I will give you a while to answer, 5 seconds. So let's get the answer right. Ravi thinks it's 2, that is a legal entity separate from its partners. And the correct answer is B and C. And Tanishka and Tanya are correct. C. Section 3 of the Act says that a limited liability partnership is also a body corporate that is formed. So in itself, it is a body corporate, and it is also incorporated under this Act, and it is a legal entity separate from that of its partners. So the incorporation of LLP, we can also take away from Section 3 that incorporation of LLP is done under the LLP Act 2008, apart from these two other things that we learned, body corporate and a legal entity separate from that of its partners. Next question. An LLP shall be governed by the provisions of which of the following? The Companies Act, the Limited Liability Partnership Act, the Cooperative Societies Act, the Indian Partnership Act. And you have 5 seconds. This might be a bit too quick, but we need to be a bit too quick. These are simple questions. What do we think? 2. And that is the correct option. Sometimes people get confused thinking that the Companies Act will deal with this only. No, the specific act will deal with it. Next question. Can a Hindu undivided family become a partner in an LLP? 1. Hindu undivided family may become partner of LLP provided that the registrar may grant permission in this behalf. 2. No. Hindu undivided family cannot become a partner in the LLP. 3. Yes, Hindu undivided family may become a partner of LLP. 4. None of the above and it cannot be determined. So, which of the following is it? It categorically can become an LLP partner. It can only become an LLP partner when the registrar grants a permission. It cannot become an LLP partner, or it is undetermined. What do you think? This is an important question, guys. I'll not move on until you try to guess. Let's just try to guess. What could it be? Yes, no, or only with registrar's permission, or undetermined? Just make a simple guess in the comments. Okay, you think with the registrar's permission. Tanishka thinks that. Rahul, what do you think? Pratika thinks no, it cannot be. The correct answer is that no, it cannot be. Why? There was no categorical bar on it. But in the case of Rashid Lal and Company versus CIT, this was taken up because it was observed by the Ministry of Law and Justice that many HUFs were admitting and trying to become partners in LLPs. And then this case was categorically taken up for this, within which, understanding the scope of Section 5 of the LLP, the Supreme Court laid down that no, what is treated as a Hindu, what is treated as a body corporate for the purpose of LLP, what is treated as a body corporate for becoming a partner in an LLP is not satisfied by a Hindu undivided family. So it cannot become a partner or a designated partner in LLP. So please remember this. It cannot become a designated partner. Next question. How many designated partners are required in an LLP? How many? Answer, possible answer 1, at least 2 designated partners. 2, 7 designated partners. 3, 2 designated partners. And 4, at least 7 designated partners. So these are different. How many partners are required? At least 2. Is at least 2 a category, or is just 2 a possible category? Is at least 7 a category, or is just 7 a category? And your timer starts now. We think it is at least 2, and we are correct. At least 2 partners. Difference between at least 2 means there is a minimum of 2 partners required. Just 2 partners means there can also be 1 partner. There can be 3 partners. There is no minimum. But we know there is a minimum per Section 6 of the Act. At least 2 partners are required for the formation of an LLP. Next question. The LLP shall file the statement of account and solvency in a prescribed form. Which prescribed form is this? Again, the statement of account and solvency. Is it Form 8, Form 7, Form 6, or Form 5? This is a form that features through most of the paperwork in LLPs. So I hope you get this right. Come on, guys. No guesses. We have 7, 8 of us here. This is Form 8. Form 8 is mostly used. You'll see that the prescribed form here. The statement of accounts and recovery in prescribed form shall be filed by LLP with the registrar every year. Section 34, subsection 3 states this. And the prescribed form for this purpose is form number 8, as we learn from the rules of the Act. Question 6. Who is the authority that grants compounding of offense under the LLP Act? So as we know, there is a possibility of compounding offenses under the LLP Act. Of the offenses that are under the LLP Act itself, they can be compounded. 1, registrar of firms. 2, the central government. 3, the registrar himself. Or 4, the registrar of cooperatives. Your timer. It is the central government. I skipped the timer. Sorry, guys. The central government here. Please bear in mind, this is Section 39 that takes place here. Bear in mind that the central government can do it via authorizing regional directors. So the regional director, if the regional director was an option here, he could have done it. But it's only the central government that is exercising its control. So the appropriate answer is the central government. Do not get confused between registrar and regional directors. A regional director is created for the purpose of compounding offenses under Section 39 by the central government, but the actual head, the actual control of this action is with the central government. Next question. What is the time limit within which LLPs shall file annual return with the registrar? the time limit of filing annual return. Keep in mind the key words, the key components: annual return, filing, registrar. So, what is the time limit for this specific activity? Is it within 30 days of closure of financial year? Is it within 45 days of closure of financial year? Within 60 days of closure of financial year? Or within 15 days of closure of financial year? We all think it's 60. Let's have more guesses come in. Only 3 people have answered. We are right. It's within 60 days. So annual returns must be filed. Again, this gives you additional information with Form 11, not 8. Annual returns are for Form 11, and the time period is with 60 days. To whom? Registrar. So these components come together. Registrar, annual return, 60 days of filing, and Form 11 is the prescribed form here. Next, every LLP shall keep books of accounts which shall contain which of the following. So, what must a book of account contain? Statement of cost of goods purchased, inventories, work in progress, finished goods, and cost of goods sold. Is it this? Or option 2, is it a record of the assets and liabilities of the LLP? Or 3, is it the particulars of all the sums of monies received and expended by the LLP and the matters in respect of which the receipt and expenditure takes place? So, like all of its, ins and outs of money. Or is it 4, all of the above? What do the rest of us think? Okay, we think it's all of the above. Let's see. We are right. It's all of the above. Why? Rule 24.2 of the rules of LLP, it states that account book shall contain all of the following. So, including all of the options we just had. 9. At which place shall the LLP maintain its books of accounts? Where does the books of accounts take place? Where is it situated, the maintenance of it? Is it at its branch office? Is it at its corporate office? Is it at its head office? Or is it at its registered office? So, very important offices, all 4 of them. But where is the maintenance of books of accounts done? We think it's the registered office, and that is correct. So section 34(1) provides that the registered office is where the maintenance of books of accounts happens. Again, another question for books. So the LLP shall maintain proper books of accounts relating to its affairs for each year of its existence. On which basis? Which basis is allowed for the LLP to maintain its books of accounts? Is it the accrual basis? Is it the double entry system of accounting? Is it the cash basis? Or is it all of the above? Can it be any of these? Ravi thinks it's the accrual basis. What do the rest of us? Medha thinks it's all of the above. And Medha is right. So there is no particular, thing pointing towards that it must be the accrual basis. It can be done in any of these forms. Next, who shall sign the statement of account and solvency prepared by the LLP? So the LLP prepares this document, the statement of account and solvency. Who shall be signing it? What is the requirement for the signature of this document? Can it be done by any one partner authorized in this behalf to do this thing? Or must it be done by at least 2 partners who are authorized to do so? Or does it have to be done by all partners? Or is it required to be done by all the designated partners? What do we think? Your time starts now. Tanya thinks all of the designated partners. No one else? Medha also thinks that. Ravi, what do you think? Pritika, Ati Divya? Pritika also thinks yes, that is correct. So all the designated partners need to be signing the statement. The statement of account and solvency is required to be filed by the LLP. That was signing. Now we are moving on to filing. It needs to be filed by the LLP with which of the following bodies? The registrar of co-op societies. They don't need to file it with any of them. The registrar simply, or some other body which is not in the options. Which of these is correct? Where does it need to be filed? Divya thinks it's the registrar. I'll start the timer now. Ravi thinks it's the registrar himself, not the registrar of co-ops, and not that it does not need to be filed. And we are correct. It is the registrar himself. It needs to be filed with the registrar. Next question. Whether in corporation documents, names of partners and changes, if any, statement of account and solvency and annual return field with the registrar can be inspected. Can all of these accumulation of documents, can these be inspected? Option 1, yes, it can be inspected by any of the partners of the LLP. Option 2, yes, it can be inspected, but only by government authorities and banks. 3, yes, it can be inspected only by the creditors of the LLP. Or option number 4, yes, it can be inspected by any person on payment of the prescribed fee. So I read it slowly so that we have a bit more time to absorb the question. What do we think? Aditya thinks it's 4. I'll start the timer now. Tanya, Medha, Pritika, Ravi, come on. Tanishka, what do you think? What is possible about the inspection? Medha thinks it's 2, 3. The correct option was 4. It is interesting because all of these documents can be inspected by any person. All that the person has to do is to give the prescribed fee, and Section 36 deals with it. Remember, Section 36 allows for any person to inspect these scores of documents. Just have to go to the registrar's office and then put in the prescribed fee. Section 36 is relevant in this aspect. Ravi, Section 36, Medha, Tanya, let's go revisit Section 36. Just a quick reading. Next question. The books of account which an LLP is required to keep shall be preserved for how many years? How many years are the books of accounts preserved for? How many years are they required to be preserved for? 1, 8 years, 2, 6 years, 3, 4 years, and 4, 2 years. Ravi thinks it's 6 years. I'll start the timer now. Or was that the earlier question, Ravi? How many years does it require to be preserved for? I'll give you the correct answer. The correct answer is 8 years. Okay. So the affairs of it can be done on cash basis, accrual basis, other basis, and they have to be required to be maintained at the registered office, we know, and they are required to be maintained and preserved for 8 years from the date on which they are first made. So the correct answer for the preservation question is 8 years. Next question. What is the fee paid? Now this, just I would suggest make a table of these transitions of fee paid and amount of money, contribution and amount of money relevant. So that will help you. Just go from an ascending scale, and in the table that will help you do that with the answers here. The question is, what is the fee to be paid to the registrar for filing of the statement of account and solvency, or the SAS, where the contribution does not exceed rupees 1 lakh? What will the fee paid be? Is it rupees 200? Is it rupees 50? Is it rupees 100? Or is it rupees 150? Your timer has begun. And your correct answer is rupees 50. So where it is under 1 lakh, no, Aditya, it's not 100, it is 50. Where it is under 1 lakh, the correct amount will be rupees 50 only. Another question, pay attention. What is the fee to be paid to the registrar for filing of SAS where the contribution exceeds 5 lakhs but does not exceed 10 lakhs? So between 5 and 10, what will be the fee paid here? 200 rupees, 100 rupees, 50 rupees, or 150 rupees? What do we think? Let's use simple elimination. Just because it was 50 for under 1 lakh, it cannot be 50 for the same. So let's just eliminate option 3. What are we left with? What do we think? What is our best bet? Ravi thinks it's 100 now. Atidivya also thinks it's 100. I'll start the timer so that we have added pressure. Tanya, Tanishka, come on. Medha, Pritika. And the correct answer is 150, guys. We went from under 1 lakh to 5 lakh and above, 5 lakh to 10 lakh. So 150. We cannot have an abrupt. That gives us another clue. Let me see who caught that clue. What is the fee to be paid to the registrar for filing of the statement of account and solvency where the contribution exceeds rupees 10 lakhs? Now we are moving north of 10 lakhs. Is it 200, 150, 100, or 50? Let me see who got the clue, guys. What is the correct answer here? Your timer has begun. Come on. Any guesses? This is above 10 lakh. Your correct answer is, yeah. Yes, guys. Sorry, there must be a mistake. This is 200. This is 200. So your next question is, who shall fix the remuneration of the auditor? So the auditor appointed under the Act, who shall fix the remuneration of the auditor? 1, the designated partners shall fix the remuneration themselves. 2, as per the procedure laid down in the LLP Act. 3. The registrar may fix the remuneration. Or 4. Both A and B are correct. What do we think? So, fixing of remuneration of the auditor, who may do it? Is it done by the designated partners, by the procedure that is explicitly laid down in LLP, or by the registrar only, or is it done by both A and B? Timer has begun. Ravi and Aditya have already answered. Excellent. Pritika has already answered. Tanya, we are correct. Both A and B are the relevant answers here. So the designated partners can do it, or otherwise, per the procedures laid down in the LLP agreement as well. They can agree to something otherwise, right? So they can always have that recourse to that course of action. Next question. LLP shall file its annual return in which form? We should know this already. Which form is annual return for? Form 12, Form 11, Form 10, or Form 9? We should know this, guys. We discussed it. Annual return. Which form is relevant here? Form 11, thinks Tanya. I am starting the timer. Ravi, Meda, Atidivya, Pritika, Tanishka. Tanya was right. We discussed this before. Annual returns go with Form 11. Next question. What is the fee for inspection of documents? Purely the fee for inspecting documents that we read about. Any person can call for inspection of documents, right? So what is the fee that they have to pay? Rupees 200, rupees 150, rupees 100, or rupees 50? The timer has begun. The fee payable if you want to inspect documents. And the correct answer here is, Veda is correct. It is rupees 50 only. Next question. What is the fee for obtaining a certified copy? If you want to obtain a certified copy of the contents or anything regarding the LLP, its incorporation. So is it rupees 3 per page or a fractional part thereof? Is it rupees 5 per page or a fractional part thereof? Is it rupees 2 per page or a fractional part thereof? Or is it rupees 1 per page or a fractional part thereof? Meda, Tanya think it's rupees 2 per page. I am beginning our timer. Our trusty timer has gone off. We do not have much to answer these questions. These are supposed to be easy. And it is answer number 2. For a copy or an extract of a document, section 36 states that rupees 5 per page or a fractional part thereof is required to be paid up. So rupees 5 per page. Next question. What is the fee for filing, registering, or recording notice of appointment, secession, change in name, address, designation of a partner or designated partner, intimation of designated partner identification number DPIN, and consent to become a partner or designated partner in Form 4. So for all of these things or any of these things, what is the fee that you want to pay up for filing, registering, or recording notice of any of these? Is it rupees 50, rupees 100, rupees 150, or rupees 200? Your time has begun. Ravi, do you think it's 2 or 1? You think it's 50. Tanishka thinks it's 50, and we are right. So for these activities, Form 4 is relevant, and rupees 50 is your required prerequisite fee. No, Tanya, not 100, only 50 rupees for this. 23. Where an auditor is unwilling to be reappointed, he shall give a notice in writing to the effect at the LLP's registered office before the end of time allowed for appointing the new auditor, along with the statement of circumstances connecting with his ceasing to hold office. But what is the time period for this? Shall this be done in not less than 28 days, not less than 21 days, not less than 14 days, or not less than 7 days? So he's asked to be reappointed, but he's unwilling. Now, when should he be doing this? Tanya, what do you think? Not less than 21 days, 28 days, 14? We think not less than 28 days. Some of us here, it is not less than 14 days. So when an auditor is unwilling to be reappointed, he needs to give, the specific notice in writing and also provide the reasons for why he cannot rejoin within 14 days before the new process is started, the new auditor's process. Now, question number 24, the removal of auditors. Who can remove an auditor from his office? 1, can the partners of the LLP do so from time to time? by following the procedures as they have themselves laid down in the LLP agreement. Two, if the LLP agreement does not provide for the removal of an auditor, the consent of all the partners shall be required for this purpose. Three, the registrar may do this himself, the removal himself. Or four, both A and B are correct. So they may either remove him as under the LLP agreement notice, or if there is no LLP agreement clause for this, for removal of auditor, they may consent together. So here we are receiving options. The correct option votes for the registrar. The clock has started. The rest of us can answer. Medha also thinks it's three. And it is only the partners of an LLP have the power and authority, not the registrar. So they are appointing the auditor there. They have the power and authority to remove the auditor from time to time, however they deal with it, and they need to do so by following the procedure stated in the LLP agreement. So that will make option 4 correct. So either they do it per their prerequisite agreement in the LLP agreement, or they go by the LLP Act rules, but they have not uh, gone through it, or they consent together on how they have to move forward with the removal of the specific auditor. Next question, 25. The designated partners may appoint auditors, but if the designated partner fails to appoint the auditor, then who will make the appointment of the auditor? We have to see the pattern we see in LLP is that the auditor is closely associated with the LLP designated partners and partners themselves, because it's for the internal purposes. And the registrar may have things to do, but the partners are very important for his appointment, his removal. So, who will do it if the designated partner fails to appoint the auditor? Will it be done by the registrar of cooperative societies? Will it be done by the other partners of the LLP? Will it be done by the registrar of firms, or will it be done by just the registrar? What do we think? I have started the timer, guys. Medha thinks it is the registrar. Atidivya, very various options coming in. So the remaining partners may do so. I even gave us a hint. Okay, I even told us here that the remaining partners, the partners are very closely associated with the appointment, removal, and everything of the auditors. It's not something externally built out and uh, externated to the registrars. The auditors are closely linked with the LLP members themselves. They are for the purpose of the LLP and for the furtherance of the objects of the LLP. 26th question here. What is the fee to be paid to the registrar for filing a statement of account and solvency where the contribution exceeds 1 lakh but does not exceed 5 lakh? Going back to the hints that we dealt with earlier. Yes, I even gave a hint for this, Ravi. Now, I even gave a hint for this other question also, for question 26. So, let me see if you got the hint. So, what is the contribution? What is the filing amount here? This is for 1 lakh to 5 lakh. We dealt with under 1 lakh, we dealt with 5 to 10, we dealt with above 10. Tanya thinks it's 150, but Tanya, yeah, it could be 150. But Tanya, don't you think we did 150 earlier? I'm starting the timer. Remember, under 1 we had 50 rupees only. So this will be 100. Yes, guys, we even dealt with hints only. Pratibha got it right. This is 100. We went from 50, then 100, then 150, and then we went to 200. So the threshold of the amounts was 1 lakh, then 1 to 5 is 100, then 5 to 10 is 150, and 10 above is 200. That's why I said make an ascending table. Next question. An auditor or auditors of an LLP shall hold office in accordance with the terms of his or their appointment and shall continue to hold such office till the period of what? What period should they do this till? Till they are reappointed. 2, only for 1 financial year. 3, the new auditors are appointed. So when a new auditor comes in, just like the vice president we see, a new vice president comes in, only then can he leave. Or 4, options A and C are correct. So till they are reappointed or till the new auditors are appointed. I'll start the timer. We think both options 1 and C are correct. We are Divya and Ravi and Tanishka also. Let's see. And we are right. So the auditors or auditor of an LLP will stay in office till the appointment. They will continue to hold office until they are reappointed. And if they are reappointed, the new person will come in, or otherwise the new person comes in and they have to wait for the appointment of the new person. So both A and C were correct. I even took us back to the constitutional law quiz, the vice president's analogy. Same thing happening with the auditor. Next question. See, the essence is that we need a VP at all times. We need an auditor at all times. That's the essence. The audit of accounts of every LLP is not compulsory if it's which of the following things happen. If its turnover does not exceed in a financial year rupees 40 lakhs, or its contribution does not exceed rupees 25 lakhs, or if the turnover does not exceed 30 lakhs and contribution does not exceed 25 lakhs, or the turnover does not exceed 20 lakhs and the contribution again does not exceed 25 lakhs, or the turnover does not exceed 10 lakhs and the contribution does not exceed 25 lakhs. So the contribution not exceeding 25 lakh, but the turnover, is it up till 40, up till 30, up till 20, or up till 10? That makes the auditing non-compulsory. Tanishka, Pratibha think it is up until 10 lakhs. The turnover up until 10 lakhs, you don't have to compulsorily audit your accounts. Ravi thinks it is 1, and Ravi was correct. So your turnover up until 40 lakhs, where your contribution within these 40 lakhs or 25 lakhs, that allows you to claim that, okay, we do not need a compulsory audit. We can go for a voluntary audit, but the auditing is not compulsory up until 40 lakhs, but the contribution should not exceed 25 lakhs. Next question. What are the penal provisions for the LLP if any LLP fails to comply with the provisions of Section 35, which deals with the filing of annual return with the registrar? So if you are not filing annually the return with the registrar, what is the punishment? What are the penal provisions under the LLP? Should you be punishable with a fine not less than 10,000 but up to 5 lakhs? Or is it a fine not less than 15,000 but up to 5 lakhs? Or is it a fine not less than 20,000 but up to 5 lakh? Or is it a fine not less than 25,000 but up to 5 lakhs? What do we think? I'll start the timer. What is the lowest limit of the fine imposed? Is it 10, 15, 20, or 25? Meda thinks it's 25. What else? It is 25. So you can go to section 29 of the Act. No, it's not 25, it's 10. So that makes it option 1. Sorry, guys. So section 29 states that the minimum amount of fine levied for a contravention of this section of section 35 of the Act shall be 10,000. And it can even go up to rupees 5 lakhs. So 10,000, bear in mind, 10,000 is the minimum fine. Maximum fine can go up to 5 lakhs if you're not annually filing the returns. Next question. What is the periodicity of preparing the statement of account and solvency by the LLP? When should it be prepared? The preparation of the statement of account by LLC. So yes, Tanya, section 35 for the earlier question. So is it within a period of 3 months from the end of each financial year? Is it within a period of 9 months? Bear in mind, this is the preparing of the statement of account and solvency. Is it within a period of 9 months from the end of each financial year? Is it within a period of 12 months from the end of each financial year? Or is it within a period of 6 months from the end of each financial year? I'll start the timer now. And the correct option is the statement of account of solvency. It is to be filled on or before October 30th of every financial year. So it is to be filled and provided before October 30th of the financial year. And the date due for the annual return of it is 30th May of every financial year, even if the company cannot even cop out that we have not completed the business in that specific financial year. It still has to provide it by the annual return by May 30th, and it needs to be filed on or before October 30th. The correct option is 6 months from the end of each financial year, because October marks 6 before the May marks 6 before the end of any October marks 6 before the end of every financial year, which is 6 months away from April. I hope you got this and didn't get confused. So 6 months before the end of financial year, 6 months before April, marking October. Next question. What are the penal provisions for LLP if an LLP fails to comply with Section 34, we did Section 35 before, now we are dealing with failure to comply with Section 34. What does Section 34 deal with? Maintenance of books of accounts, other records, and audits. So if you fail to do any of this, what shall the fine be? 15,000 to 5 lakhs, 25,000 to 5 lakhs, 20,000 to 5 lakhs, or 10,000 to 5 lakhs. I'll start our timer. Tanya thinks it's 10,000. No, 25,000. Yes, we were correct. Option 2 was 25,000. 1 was 10. So if a partner, a limited liability partnership fails to comply with Section 34, the punishment under Section 34 provided is that it shall be 25,000 to 5 lakh rupees, right? And every designated partner of the LLP will be punishable with the fine. Next, what happens? Sorry, this question is added twice. What are the penal provisions for, I think I'm going back mistakenly. Sorry, guys. Yeah. What is the penalty for the false statement made by the LLP in any return, statement of other documents required by or for the purpose of any of the provisions of LLP Act? So if a LLP is making a false statement in a return or in a statement of other documents, right? So if it is falsifying its accounts and its documents, what is the punishment levied by the LLP Act? Is the person concerned made punishable with imprisonment up to 1 year and fine between 1 lakh and 5 lakh? Is the person concerned for this action made punishable for a period of imprisonment up to 2 years and the fine being 1 to 5 lakh? Or is the period of imprisonment up to 3 years, the fine 1 to 5 lakh? Or is the period of imprisonment 4 years, fine 1 to 5 lakh? So we think here most of the options are coming in favor of 2 years, imprisonment up to 2 years. Let me give us a while. We have someone else who has also joined us. CK, please reveal your full name. Yes, the correct answer is not 2 years, but 1 year. The penalty for falsifying the statements by an LLP in any of these areas is imprisonment, which may go up to 1 year, but the fine again stays between 1 to 5 lakh rupees. Next question. So if a person fails to comply without lawful excuse with the summons or requisition of a registrar under Section 38, right, where the registrar is seeking information under his powers, what is the penal provision? What can he be penalized with? He shall be punishable with fines between 2,000 to 25,000, punishable with fines between 1,500 to 25,000, between 1,000 to 25,000, or between 500 to 25,000. This is to, fail to provide the requisite information to registrar when the registrar is only acting under his duties. So we think it is 2,000 to 25,000. Let's see. The correct answer is 2,000 to 25,000. Section 38. Not complying with Section 38 of the Act renders a punishment of between 2,000 and 25,000 rupees. That is the correct answer. Good job, guys. Next question. An individual or body corporate cannot be a partner in a limited liability partnership. So, of this, can only body corporate form an LLP? Can only individual form an LLP? Or is the statement provided wrong? Or is the statement provided correct? Which of these options is correct? Either option 1 is correct, which disproves part of the statement in the question, or option 2 is correct, disproving the other part of the statement in question, or we can go with option 3, which states that the entire statement in the question is incorrect, or we can go with option 4, stating that the entire statement in the question is correct. So Medha thinks it is that only body corporate can form an LLP. Tanya thinks that the statement is wrong, that neither individual nor body corporate, sorry, that both individual and body corporate can be partners in an LLP. Again, pay good attention to the phrasing of the question. An individual or body corporate cannot be a partner in a limited liability partnership. So, Meda, I'm starting the timer. Ravi, rest of us, Aditya thinks 3, the statement is wrong. See, we already know body corporate allowed. The statement is entirely wrong. They are allowed. Individual, body corporate, they're allowed to be LLP partners. What we see is not an LLP partner, is a Hindu undivided family, as we saw through the case we discussed in the first few questions. Minors, persons of unsound mind, undischarged solvents, right? Undischarged solvents, they cannot be partners of an LLP. Next question. So, what is LLPIN? What is meant by LLPIN, the sign LLPIN? Is it actually just CIN? Is it referring to every LLP which is registered with the registrar? Because then it is given an LLP identification number and then called LLPIN. Or is it DPIN? Is it synonymous with DPIN? Or is it just like DIN? Which of the options is it? What is the significance of the term LLPIN? So if we see the term LLPIN in forms and wherever, I'm sorry, there's some issue. The correct option is 2. So it is just that the registrar puts an identification number along with it, and that is what LLPIN refers to. Next question. Every limited liability partnership shall have at least 2 designated partners who are individuals, and at least one of them shall be whom of the following: an Indian resident, a person of foreign nationality, a person who is a resident in India, or a person who just has an Indian passport. So, what is the requirement? We know that a minimum of 2 people is required for LLP formation. Now, what is the requirement for one of them? At least one of them needs to be which of the following? And some of us here think that it is an Indian resident. Let's see. And the correct answer is yes, Indian resident. Again, we need 2 partners at least, one of whom shall be a resident in India. Next question. In terms of Section 23(2) of the LLP Act, every LLP shall file information with regard to the LLP agreement in the prescribed form with the registrar within 30 days of information. Again, so 23(2) of the LLP Act, filing of information with the registrar in the prescribed form within 30 days of receiving such information. The prescribed form number for Section 23(2) shall be what? Form number 2, form number 3, form number 4, or form number 1? The correct answer is form number 3 for this purpose. For the purpose of Section 24(3), form number 3 is required as a prescribed form. So filing information is for form number 3. Next question. The court or tribunal may reduce or waive penalty leviable against any partner or employee of LLP if it is satisfied that. So this is reducing penalty, waiving penalty. When can the waiving or reducing of penalty be done by the authorities, that are the courts or tribunals? 1, when any information given by any partner or employee leads to LLP or any partner or employee of such LLP being convicted under this act or any other act. So they are, whistleblowing, not whistleblowing, but they are giving out, they're informing against each other. 2, when such partner or employee of LLP has provided useful information during investigation of such LLP, where the information is otherwise useful. 3, both options 1 and 2 are correct, or 4, none of the above. And I've begun the timer. Tanishka, Tidivya think both options 1 and 2 are correct. Tanya thinks options 1 and 2 are correct, and we are right. So Section 31, like I said, whistleblowing. If you're informing on the activities, the insider activities of someone else and incriminating them, thus providing information or otherwise valuable information, you're protected under Section 31 of the LLP Act. So what the court or tribunal can do, it can waive off the penalty, or it might significantly reduce it against the quality of information you have provided. Next question. Every partner of a LLP is for the purpose of the business of the LLP. What? What is the significance of every partner of LLP for the purpose of that LLP? Is he an agent of the LLP itself but not of other partners? Is he an agent of the LLP as well as an agent of the other partners? Is he an agent as well as the principal of the LLP, or is none of the above correct? So, can we have some guesses come in? Tanya thinks he is an agent of the LLP but not an agent of the other partners. Pratibha, Divya, Tanishka, Medha, Ravi. Medha thinks again an agent of the LLP but not an agent of other partners. Come on, the timer has started. We don't have long. Pratibha also thinks the same, and that is correct. See, Section 26 explicitly states that in an LLP, every partner is a agent for the purpose of the LLP, but not an agent for the purpose of other partners. So he may share an agent-principal relationship for the purpose of LLP, but not amidst the partners. That relationship does not exist amidst the partners. So Ravi, I hope you got that. I hope you're attentive. This is a key important factor, agency between LLP and its partners. Next question. The annual return, just a moment, I hope you are not. Yeah. The annual return of an LLP having turnover up to 5 crore rupees during the corresponding year or contribution up to 50 lakh rupees shall be accompanied with a certificate from a designated partner other than the signatory to the annual return to the effect that annual return contains true and correct information, right? So the annual return of LLP, what are the factors of the LLP? The elements: it has a turnover up to 5 crore rupees during a corresponding financial year, or it has a contribution up to 50 lakh rupees. And then the annual return shall be accompanied with a certificate by a designated partner other than the signatory to the annual return. So anyone who is signing the annual return, not that person, another person who is a designated partner, so that he signifies there that all the contents of this annual return are true and correct, right? So this is one thing. But in all other cases, the question is asking, apart from this, in all other cases, the annual return shall be accompanied with a certificate from a person to the effect that he has verified the particulars from the books and records of the limited liability partnership and found them to be true and correct. Now, who is this person? Who shall be providing this certificate? Who shall be stating? In the other place, we saw that the signate, apart from the signatory, the other person is certifying, the other designated partner is certifying that the contents are true and correct. Now, apart from that, a company that does not have a turnover up to 5 crore rupees or is not having contribution up to 50 lakh, who shall be making this attestation there? Shall it be the company secretary in practice? Shall it be the cost accountant in practice, the advocate, or shall it be chartered accountant in practice? Tanya thinks it is the CA. Is that right? Are we having any troubles with this question? So we established the normal procedure in the question before. Then apart from this, in all other cases, who shall be making the certification of truth? I'm starting the timer. Tanya thinks it is the CA in practice. Is it the cost accountant, the company secretary, or the advocate? It is the company secretary. Only at the Divya is right. The company secretary in practice needs to make this. The job of the company secretary is to keep compliances in check. He has to make sure everything is happening legally. So these things, these attestations fall within the purview of the company secretary, not the cost accountant. The cost accountant does something else entirely. The chartered accountant does something else entirely. The company secretary takes care of the compliances and legalities. Next question. In terms of Section 25(2), where a person becomes or ceases to be a partner, or where there is any change in the name or address of a partner, the LLP shall file with the registrar a notice in. So if there is a cessation of a person becoming a partner, or if a new person becomes a partner, or the name or the address of the partner changes, so these things are alterations. These alterations are made in terms of Section 25(2) in the LLP. In which form? In which form shall the notice be sent and filed? Shall it be form 5, 6, 3, or 4? And we are starting the timer. So changing of name, address, cessation of a partner being a partner or a new partner, it is done in form number 4. The prescribed form for these alterations is form number 4. So just make a quick little table: form number 4, form number 11, form number 8. These are the majoritarily, they feature a lot in most of the work. Next question. If the LLP contravenes the provisions of Section 24(2), which relates to the information of the registrar about any changes of succession of partner and change in the name and address of partner, the LLP and every designated partner of the LLP shall be punishable with which fine. So the provisions of 24(2), which relate to giving information about to the registrar, we saw earlier that the registrar is bound to seek information. So if the LLP is contravening this function of the registrar with respect to changing uh, of partner's name, address, the succession of a partner, being a partner, what shall be the penalty levied on that person? Fine between 2,000 and 25,000 rupees, fine between 4,000 and 25,000 rupees, fine between only 1,000 and 25,000 rupees, or fine between 3,000 and 25,000 rupees. So Tanya, Tanishka, we are going to be judges. We should know this. We will have cases where the contraventions happen. What are we going to award there? Okay, let's see. Tanya will award a fine between 1,000 and 25,000 rupees. Tanishka will award a fine. No, Tanya has changed her sentence. Tanya is now awarding a fine between 2,000 and 25,000 rupees. And we are all doing the same. Okay, so now all judges are following Judge Tanishka. Interesting. Let's see if the verdict is right. Everyone is following suit. Okay, so Tanishka seems to have laid down a precedent, and Tanishka is correct. Excellent, Tanishka. The fine here shall not be less than 2,000 rupees, but it may go up to 25,000 rupees. Next question. A person shall not be capable of being appointed as a designated partner. Now, not just a partner of an LLP. We are moving on to the designation, designated partner. Appointment as a designated partner. Now, who will not be appointable as a designated partner? If a person who has suspended or at has any time within the preceding 5 years suspended payments to his creditors and has not at any time within the preceding 5 years made a composition with them. So a person who has either presently suspended payments or 5 years back has at any point suspended payments with his creditors and not made a composition with them, can he not be a designated partner? Because see, these things clearly maim the name. They clearly tarnish the name as a credible partner in an LLP, as a businessman, basically. Or is it two, a person who has been convicted by a court for any offenses which involves moral turpitude and has been sentenced in respect of this, and the punishment for this is above 6 months, or has been convicted by the court for an offense involving Section 30 of the LLP, or a person who has at any times within the preceding 5 years been adjudged as an insolvent. So he is a certified insolvent. Or is it all of the above? And we all think it is all of the above. Let's not jump. We see this pattern quite a lot. You are jumping. Just read through the question at least properly. Maybe the question had an element can or cannot. What would you do? You would just skip ahead. This is what I kept reminding us all in the constitutional law quiz as well. Don't skip ahead, read it well. So rule 9.1 gives all these conditions supplementing section 7 of the LLP Act, which deals with who a designated partner can be and who a designated partner cannot be. Rule 9.1 supplements it and states that a person with any of these qualities or multiple of these qualities will not be allowed to be a designated partner. Next question. A limited liability partnership. What is a characteristic trait of a limited liability partnership? Does it have perpetual succession? Or does it only operate for 5 years? Does it not have perpetual succession? Or does it operate for a limited time, which is not 5 years? Your time has started now. So does it have perpetual succession? Does it only operate for 5 years? Does it not have perpetual succession? Or does it operate for? It has perpetual succession. See, section 3 subsection 2 tells us that a limited liability shall have perpetual succession. Next question. How many partners are required to form LLPs? It shall have at least more than 2 partners. It shall have at least more than 7 partners. It shall have at least 2 partners. It shall have at least 7 partners. So again, another question to throw you off. Just option 3. Yes, option 3 is correct. I wanted you to read it and possibly get confused between 1 and 3. Option 3 here is correct. So the partners required mandatory minimum requirement is at least two partners. It can have more than two partners, that is not incorrect, but the question states how many partners are required, and option 1 says that it shall have at least more than two partners, which is incorrect. It needs to have at least two partners only, not more than. And then, yes, section 6. The correct option is 3, which is it shall have at least two partners. Next question. In terms of section 7.3, an individual shall give his prior consent to act as a designated partner of the LLP in the prescribed form, which is. Now for section 7.3, what is the prescribed form for giving consent that yes, I am a designated partner? Already told you section 7 deals with appointment, of a designated partner. So what is the form where this person has to consent that yes, I shall be acting as a designated partner? Is it 9, 8, 11 or 10? Come on guys, let's take a guess, an educated guess. Which of these forms seems very, very important for this purpose? We have kind of unlocked the purpose of forms. We have seen which forms deal with alterations, which forms deal with form 8 to, let's give us a bit more. So because of the highlighted importance of 8, we are thinking 8, and the correct answer is form 9. Form 9 has to be the place where this consent of acting as a designated partner has to be filled in. So form 9 is for this. Next question. What is the filing fee for LLP in case where the contribution of LLP exceeds rupees 10 lakhs? So I expect us to answer quickly. 150, 250 or 100. Filing of LLP. What is the filing fee for LLP in case where the contribution of LLP exceeds rupees 10 lakh? We are thinking it's 200. Ravi, Pratibha. Pratibha has given a guess in. Yes, 200. We discussed this before. Next question. When shall a person cease to be a partner of a limited liability partnership? When shall a person cease to be a partner? So cessation of becoming a partner. We dealt with the concept, we saw the concept a few questions ago, but we don't know the grounds of it. So when does cessation of partner happen in an LLP? 1, only if he is declared to be of unsound mind by a competent court. 2, if he has applied to be adjudged as an insolvent or declared as an insolvent. 3, only on his death or dissolution of the LLP. Or 4, none of the above. Okay, I'm seeing a few votes for 2, a few votes for 3. So Ravi and Meda think it's only on death or dissolution, and the others think if he has applied to be adjudged as an insolvent or declared as an insolvent. See, the correct option is 2. This is the importance of reading questions well. Section 24 has all the elements. Yes, it has option 1 as well, it has option 2 as well, and it has option 3 as well. But look closely at how the options are stated. Option 1 says only if he is declared to be of unsound mind by a competent court, and it is not exclusive. It can be if he is declared to be an unsound person by a competent court. It can be when he is an insolvent. It can be when he dies or the LLP is dissolved. So the use of the word only makes the option exclusive, which is not true as per section 24. So cessation of partnership can happen in any of these cases and not exclusively in one of these cases, which means that only option 2 is correct, because it generally says if he has applied to be adjudged as an insolvent or declared as an insolvent. So this is the significance of reading your questions properly. Your next question is, and after this we'll take a little break. As you can tell, my health is not at the best. I cannot speak well, so I'll need a tiny break, and we'll also use this to discuss few things and for you to get refreshed. The question is, publication of name and limited liability is provided in which section of the LLP Act? Now we'll have just easy breezy questions going on and a few complicated ones. So publication of name and limited liability, which section of the Act deals with it? 24, 22, 21 or 23? Your timer has begun. Let's see some guesses. Pratibha thinks it is 21, 321 by Tanya, and we are correct. Section 21 of LLP Act 2008 deals with the publication of name and of a limited liability partnership. So let's take a brief breather. So, guys, how are we feeling? Yes, guys, can we get a few comments here? Can we get a few catch up messages on how the spirits are, how the preparation is? Let me know. Medha, Ravi, how do you feel so far? Ravi feels great, excellent. So, how are you feeling with the provisions of fate? Do you feel like you need to, revisit them a lot? Tanya feels great. Well, great to know. I hope you keep feeling. Yeah, see, Pratibha, the questions on what form is for which thing, these are in the rules themselves. So you'll have to consult the rules. But the best part is that you don't have to consult all the rules, right? And it's just focus on the key portions we tell you and focus on the key portions highlighted in the content that Lossico is providing you. And thank you, Medha. I am glad that you made good use of the questions. So, Pratibha, just don't get overwhelmed. The forms are important. Just make a quick tabulation of, I'd say, Form 8, Form 11, Form 9, Form 3. Just revisit them a bit and, basic things, important things that uh, are key to the functioning or the creation of an LLP. Which forms are consulted and which thing, that is a point of issue, that is something you need to revisit and learn consistently. So again, as Tanishka is saying, you just need to revisit that bit, but that does not mean that you have to read all of them, and at the same time just also make your own educated guess on what should be read and what not. But as always, our content is there to point you towards the right direction. Just make sure you are making the best use. If you're making the best use of the content, you have the best chances, right? So procedure of a fine is a bit confusing from section 6 onwards. Yes, just Ravi, just read through the Bear Act once more. Just try to have you taken the MCQ this morning, this noon? I just want to know that. If you have, retake it. If you have not, just make sure you're taking it. You've taken it. So how did your paper go this morning? Or how did your marathon? Did you also attend the marathon? Just make sure, see, all the resources that are provided are very comprehensively designed, and they help you. They help you out. So I hope we are doing better. Shall I resume with the questions? Yes, you just need to go through it again. Just make sure you're reattempting the mock. And then we have full length mocks, guys. Full length mocks at the end of this are just very, very important, because see, you have gone through individual subject mocks, subject wise mocks, and there your thinking is very linear. Oh, I'm thinking about constitution provisions, I'm thinking about CRPC, not about evidence. But you need to be prepared for quick thinking, and that is what the full length mock does. It does that, and it also gives you more questions to practice. So the questions we are using, we won't test you for those in full length mocks. We'll give you other questions, of course. We want to give you original and tough questions, and we want to increase the chances of you being very prepared. So anything we are anticipating to happen in the DJS series is in this mock test series. Anything that our educated guesses tell us, educated analysis tells us, we don't even guess. We have a just a very giant blueprint of what needs to be done. We have resources going back to 10, 12, 14 years of DJS papers that we are analyzing and figuring out what the next pattern can be, what the latest trends are indicating. And that is how we are curating all these questions. That is how we are. I know it because it's my team that's doing it. I head the mocks team. So this is why I take tiny bits of time to encourage you guys to make sure you are attempting and make sure you're participating in the mocks. So the full length mocks, if you feel like you don't want to reattempt the same LLP test 2, 3, 4 times, which is not ideal. Do it 2 to 3 times so that the concepts sit within your brain. If there is any error, if you feel like there is any error, there is anything I don't understand in this question, you have my number on the DJS group. You have it, just consult with me immediately. Just get to me immediately. It is quite possible that you might have a confusion there, which I can immediately help you with, which we can sort out and you can retain the correct concept, right? Or and then if you move to the full length mocks, you'll again, like I said, your agility, your mental agility will be tested, which we want to train you in that, because the exam won't test you with one section of evidence, two sections and 4 to 5 questions of evidence, then move on to CRPC. You have to be quick thinking. You have to make sure you're not confusing questions on CRPC with questions on evidence. You have to be good readers for your questions, right? And in answering your questions. So every resource that has been provided to you has a purpose, and don't make the mistake of thinking that any activity is dispensable, that I can do without the marathon, I can do without the quiz, I can do without the mock itself. No. And if you're internal students, I know that I think Tanya is an internal student, so we have scores of content that we provide. We have scores of classes. Everything is just a building block towards the grand scheme of your passing the judiciary exam. So make sure you're putting everything to a full use. So with that, let's start again. I hope you can see it. Just notify me if you can see the screen. I can see the screen. Can you guys also let me know if the screen is visible? Okay, perfect. So let's move on. We are going to question 51. Section 12 of the LLP Act 2008 deals with. Now, I told you we are having a few easy breezy questions. What does Section 12 of the LLP Act deal with? Is it with incorporation by registration? Is it by LLP to be a body corporate, that LLP is a body corporate? Does it deal with reservation of name, or does it state that the partner is an agent? The timer starts now. Section 12. Okay, we think it is incorporation by registration, and we are correct. Excellent job, guys. Section 12 is for incorporation of LLP by registration. Now, we dealt with minimum members of partners in an LLP. What is the maximum numbers of partners in an LLP? Is it 100? Is it 200? Is it 50? Or is there no limit to the number of partners in LLPs? Your timer has begun. Think very carefully. Maximum number of partners that there can be in an LLP. Tanya thinks it is unlimited. Ravi, where did Ravi go? Where did Atidivya go? Medha, Pratibha, Tanishka. We saw someone tune in. CK. That person has left. Unfortunate, and we think it's unlimited. We are correct. The statute provides, LLP Act provides no bar or fetter on the maximum amount of members who can be in an LLP. Now, we dealt with minimum partners. We did deal with minimum partners, but how many minimum designated partners are required in an LLP? 1, 2, 3, or 4? Now, let's give this our best guess, our educated guess. Minimum designated partners, considerably different from just partners. So, no guesses? Pratibha thinks it is 2 partners again. Tanya, Tadevia, yes, again, it's 2 partners. We saw it. We had an explanation. 2 partners are designated and one of them must be Indian. Next question. Who is the authority to grant compounding of funds under LLP Act? Who grants compounding of funds? Now, we dealt with compounding of offenses. That is what we dealt with before in an earlier question. Who is competent to compound funds themselves? Is it the registrar of firms, the central government, the registrar simply, or the registrar of cooperatives? I'll start the timer. Medha thinks it is the central government, just like it was for the compounding of offenses. And it is correct. The central government. Again, to remind you, who did we deal with? For compounding of offences, the central government creates regional directors and offices to extend its compounding powers. Now, this is compounding of funds, again, by the central government. Next question. How many chapters are provided under the LLP Act? How many chapters exist in the LLP Act? Do we have chapters 1 through 11? Do we have chapters 1 through 13? Do we have chapters 1 through 12 or chapters 1 through 14? How many chapters are we dealing with in LLP Act? Your time has begun. Tanya thinks we have 14 chapters in the LLP Act. And Tanya is correct. Ravi, I didn't receive your guess. Someone has the username anonymous. I hope your answers are not anonymous. I want you to know if you have got them right or not. So let's have the guess of anonymous on this question. How many sections are provided under LLP Act? So we saw chapters, 14 chapters. Anonymous, what do we think? Is it sections 1 through 83, 1 through 82, 1 through 81, or 1 through 80? How many sections are there? Come on. You must have scrolled. The first thing that we as law students do is we scroll to the end of the act to know how much of a headache this will be. Anonymous thinks we have 1 through 81 sections. I will begin your timer for the rest of us. 1 through 81. Atidevya thinks only 80. And while Anonymous is correct, 1 through 81, but 81 is no longer there. So let's also bear that in mind, 81, but we actually only have 80. So let's move on to the next question. So Atidevya, you could be correct. It could just be 80, but still 81 is there. But effectively, we have only 80 sections. The Parliament enacted the LLP Act 2008 in which year of Republic India? So which year of India being a republic was it? Was it the 59th year of Republic India, 60th, 58th, and or 61st? Now, this is something that appears in the very beginning of the enactment. It is stated that it was enacted in this year of Republic India. Atidevya thinks it's 59th. 59. This is the first thing we read. I just threw this in here for, us to relax a bit. This is the first thing we always read. This act was enacted in the dash dash year of Republic India. And okay, the correct answer is 59th year, that is 2008. No, Tanya, 59th year, 2008, the LLP Act 2008. 2008 was the 59th year of India being a republic nation. Chapter 1 deals with which of the following? What is Chapter 1 titled? Is it Introduction and Preliminary? Is it only Preliminary? Is it Introduction only? Or is it none of these? Is it titled something entirely differently? What do we think? We must know these things by heart. The first few sections where we have the titles and names, the first few chapters. Pratibha is correct. It's titled Preliminary. Chapter 1 is not titled Introduction in this. It is titled Preliminary. 59. The LLP Act 2008 extends to, does it extend to whole of India except J&K? Does it extend to parts of J&K? Does it extend to whole of India simply, or is it undetermined where the LLP Act extends to, because the LLP Act does not, specifically provide for it? Let's have the guesses come in. I've started the timer. Where does the LLP Act extend? Whole of India except J&K, whole of India, whole of... Okay, we think whole of India, and that is correct. It extends to whole of India. There is no exception. No exception of the state of J&K. Next question. What is the commencement date of the LLP Act 2008? Govind Patel has also joined us. Hello, Govind. I hope your preparations are going well, and I hope you're taking up all the mocks and marathons and quizzes. What is the commencement date of the LLP Act 2008? Is it 31st March 2009? Is it 1st April 2009? Is it 31st April 2009? Or is it 1st March 2009? Commencement date. Again, one of the few key details that we never miss. So Atidevya thinks it's 31st March. I have started the timer. Come on. Where did Anonymous go? Govind, let's have your guess as well. And that is correct. It is 31st March 2009. So the enactment was in 2008, but it commenced acting from the 31st March 2009 because the financial year began. On which date did the president give assent to the LLP Act 2008? These questions are just here because they sometimes feature. You must know these dates. Just in the back of your mind, just store these. When did the president give assent to the LLP Act 2008? Was it 31st March 2009, the same day as commencement? Was it 7th January 2009? Was it 15th February 2009? Or was it 15th March of 2009? Medha thinks it's 7th January. Pratibha thinks it's 7th January. And that is correct. That is when assent was given. Again, commencement happened in 31st March 2009. It was enacted in 2008, but assent was given on January 7th, 2009. What does Section 2 of the LLP Act talk about? Interpretation and clauses. Interpretation only, or does it talk about definition and clauses, or does it talk about none of the, or does it talk about only definitions? What do we think? I have started the timer. Section 2. This is Section 2, guys. Pratibha thinks definitions. Tanya thinks definitions. And we are correct. It does not deal with interpretation or anything else. It only talks about definitions. Section 2, just as it normally does. Section 2 almost exclusively is only left for definitions and giving meanings to words and phrases. Compromise or arrangement of limited liability partnerships. So compromises or arrangements within LLPs is given under which section of the LLP Act 2008? Is it section 58? Is it section 60A? Is it section 60? Or is it section 61? Compromise or arrangement of LLPs. I've started your timer. 58, 60A, 60 or 61. Tanya thinks it's 60. Other people, other guesses? We are correct. That is section 60. Section 60 deals with compromise or arrangement of LLPs. Next question. In which among the following cases can the tribunal may order a meeting of the creditors or of the partners in case a compromise or an arrangement is proposed? So a compromise or an arrangement is being proposed. And where may the tribunal order a meeting of the creditors or partners for this purpose? Is it where the compromise is proposed between LLP and its creditors? Is it where the compromise or arrangement is proposed between LLP and its partners? Is it where an arrangement is proposed, not a compromise, just an arrangement is proposed between LLP and its creditors only, or is it any of the above? So, key things: compromise, arrangement. Okay, compromise, arrangement, and partners or creditors. So, which combination of these is it? Tanishka thinks it's arrangement being proposed between LLP and creditors. Atidivya thinks it can be any of the above. Medha thinks it's any of the above. So whether it is a compromise, an arrangement, whether it is between LLP and creditors or LLP and partners, and that is correct. Why? Because of section 61. Section 60 subsection 1 states that in all these cases, whether it is between creditors and LLP, partners and LLP, whether it is compromise or arrangement, anonymous, this shall be in any of these cases. Please go back to section 60, read it through once. In all these cases, the tribunal has the power to order a meeting of the creditors, partners with the LLP to enable this compromise or this arrangement. Next question. In case the LLP is being wound up, an LLP will be wound up just like a company has winding up. In case the LLP is being wound up, then who among the following is entitled to make an application to the tribunal to order a meeting of the creditors or of the partners in case a compromise or an arrangement is proposed? So, upon the winding up of an LLP, who can make an application to the tribunal for a meeting for, again, the compromise or the arrangement that we were just dealing with right now? Who makes this proposal, this application? Is it the liquidator? Is it the registrar? Is it the LLP itself, or is it an inspector? Govind thinks it is the liquidator who has to make this application to the tribunal. I am starting the timer. What do the rest of us think here? Let's give a certain answer. Okay, Govind thinks it's the registrar. Tanya, Tanishka, Ravi, Medha, Atidivya. I will wait a few more seconds. Come on, guys, who will be making this application before the tribunal? it is creditors or partners or either of them are entitled to make an application. So when those right, no, it's not two. Sorry, guys, just a moment. It is the registrar. Yeah, it's two. It's the registrar or the. Just a moment. Liquidator registrar LLP. The LLP partners itself. Yes, so it is three. Sorry, as the LLP partners itself are entitled to make it. Next question. The majority to make a compromise or an arrangement. So we are going across the same direction, the compromise or arrangements between, we learned it can be between creditor LLP, it can be between partner LLP, who can make the application. The partners, the LLP itself is empowered, whether it is the creditors or the partners, they are empowered to make the application because they are participating in this thing, right? They are to benefit or to lose from this activity. So they are allowed to make applications before the tribunal. Again, the creditor, the partner, either of them. So the LLP itself is allowed to make an application. Now, what happens here in this compromise and arrangement? What amount of majority, what quorum, so to speak, is allowed here? Is it 1/2? Is it 3/4? Is it 1/3? Is it 2/5? So is it special, simple, or is it 1/3, 2/5? What proportion is required? What do we think? The correct answer is, of course, 3/4 in value. As per section 62 of the LLP Act, we go through 60, section 60, subsection 2. A majority must represent 3/4 in value of the creditors or partners, as the case may be, at the meeting, whether they agree to a compromise or an arrangement, etc., is made, wherever it is made for the purposes, and it is then sanctioned by the tribunal, then it becomes binding as an order on all of them. But the working majority here will be 3/4 in value of the people present there, of the creditors or partners. Next question. An order made by the tribunal under subsection 2 of section 60 shall be filed by the limited liability partnership with the registrar within how long after making such an order, and shall have effect only after it is so filed. So the filing of an order made by the tribunal that it is making, that we just saw that the order is binding, how long after making the order shall it be filed by the LLP with the registrar, that this is the arrangement we arrived at, please file this? Is it within 5 days of making such order, 10 days of making such order, 20 days of making such order, or 30 days? Atidivya thinks it's 30 days of making such order. Tanishka, Tanya, Medha, Ravi, Govind. It is 30 days. Section 60, a very important section in the LLP Act, we must admit. It states that the order that is finally arrived at, that the tribunal states as binding on all the parties of the compromise or agreement, is binding and everything, and then it is taken by the LLP towards the registrar for filing within 30 days of such an order having being made. Next question. The criminal cases against the LLP or its partners or designated partners or any other person in default filed under the LLP and pending before the court of judicial magistrate of the first class or metropolitan magistrate, as the case may be, shall be transferred to whom among the following? So a criminal case against LLP or its partners or designated partners or anyone along with them, which is pending before JM first class or metropolitan magistrate, where is it liable to be transferred towards? Is it liable to be transferred towards the CJM next, the High Court, a special court, or an appellate tribunal? I have begun the timer. Let's see, where can it go from judicial magistrate first class or the metropolitan magistrate? It goes to the special court. So section 77(2) of the LLP Act states that these things can be done. A criminal case can lie against LLP where it lies against LLP partners or people associated with it, and where it is pending before JM of first class or metropolitan magistrate, the special court takes it up, as we see for the deliberations about the special court in 67A. So the special court is taking up these cases here. Now, on which among the following matters is the central government empowered to make rules? Under the LLP, what can the central government make rules for? The manner of appointing adjudicating officers for judging a penalty under the Act, the payment of additional fee for filing of document or return and the payment of different fee or additional fee under Section 67 of the Act, the terms and conditions to be fulfilled by class or classes of LLP under long line to cost TA of Section 2, or is it all of the above? What can the government, the central government, make a rule about? Yes, guys, I have started the timer. What do we think? Medha thinks it is the terms and conditions to be fulfilled by. Oh, was it the earlier question? I'll give you a bit more. This is a bit long, the options here. The manner of appointing adjudicating officers, anonymous, thinks it's all of the above. So it can be for judging penalty, it can be for additional fee, filing of documents, additional fee, and all those things. It can be for terms and conditions with respect to Section 2 TA. And Ravi, I didn't see a guess from Ravi. And that is correct. All of the matters are deliberated upon by the central government when it comes to rulemaking. Section 80 of LLP Act provides for which of the following? Does it deal with power of inspectors to carry out investigations into affairs of related entities, etc.? Does it deal with seizure of documents by inspector? Does it deal with power of tribunal to enforce compromise or arrangement? Or does it deal with the power to remove difficulties? Section 80. I have begun the timer. What does Section 80 deal with? Section 80 deals with which of the following, guys? It deals with the power to remove difficulties. Next question. If a difficulty arises in giving effect to the provisions of the LLP Act 2020, Amendment Act 2021, then the central government can, within how many years of the commencement of the LLP Amendment Act, make any order to remove difficulty? So if such a difficulty originates with bringing to effect the Amendment Act of 2021, the government may act towards it within how many years of the commencement of the act. So what is the time frame allowed for such corrections and time frame allowed for such actions to bring the amendment act into full effect? Is it 3 years? Is it 2 years? Is it 4 years? Or is it 5 years? So the time frame to bring the amendment act into effect, how many years after 2021 can this still be done? Tanishka thinks 2 years. I have begun the timer. Come on, guys. Tanya, where did you go? Ravi, it is 3 years. So when we look at Section 81A of the Act, so after the expiry of period of 3 years from the date of commencement of 2021, so that means next year, till 2024, the date of commencement of the LLP Amendment Act 2021. I don't quite remember when it commenced the Amendment Act, but exactly 3 years from then, what shall happen? Exactly 3 years from then is the only window available for any orders to be made in the Act to bring into effect the amendment provisions. Next question. The time limit prescribed for preparing a statement of account and solvency is which of the following? Does it happen within a period of 1 month? So, preparing a statement of account and solvency. Does it happen within a period of 1 month from the end of each financial year? Does it happen within a period of 12 months from the end of each financial year? Does it happen within a period of 3 months from the end of each financial year? Or does it happen within a period of 6 months from the end of each financial year? We dealt with a similar question before, but not quite the same. So, preparing the statement of account of solvency. We dealt with, I think, filing it and not preparing it. So, what is the time limit prescribed? When do you need to prepare it? Is it within a one month period from the end of financial year? Is it 12-month period? So exactly 1 year before that. Is it 3 months or is it 6 months? I've begun the timer, guys. Come on. I expect some comments to come in. So it is 6 months. If you look at 34.2 of the LLP Act, it states that within a period of 6 months from the end of each financial year, so half a year ahead of the financial year beginning, you have to start preparing for the financial year's account and solvency. You know, we dealt with exactly this when I gave you the example of October. So that is when you need to deal with it. Just a moment. Where were we? Who among the following shall assign the statement of accounts and solvency? We were dealing with statement of accounts and solvency. Now, who among the following signs the statement of account and solvency? Which person? Is it to be signed by the partner? Is it to be signed by the designated partner? Is it to be signed by the registrar? Or is it to be signed by the inspector himself? Any guesses, guys? The signing of the statement of. Okay, Meda thinks it is a designated partner who has to sign the statement of account and solvency, SAS. Ravi, Tanya, yes, it is designated partners. Yes. So this shall be done by the designated partners only. Next person. Next question. Does the person who wants to inspect the documents with the registrar need to pay any fee? The person wishing to inspect documents that are with the registrar, does he need to provide any fee? Is it 1 yes, 2 no, 3 only when he falls above the poverty line, or 4 the registrar decides on this behalf? Ravi, do you think that it is only when he falls above the poverty line? Tanishka thinks yes. Meda thinks yes. Tanya, where did Tanya go? Ativya, Govind. The correct answer is yes, irrespective of where he is with the poverty line or whatever. Section 36 makes no such bars for that. The fee needs to be paid, and we saw earlier it is only 50. What is dealt with under Section 37 of the LLP Act 2008? What does Section 37 of the LLP Act 2008 deal with? Is it penalty for false statement? Is it power of registrar to obtain information? Is it compounding of offences? Or is it destruction of old records? Your timer has begun now. Ravi thinks it is penalty for providing false statements. So the LLP is providing false statements. We dealt with those provisions, and that is correct. Section 37 deals with it. We saw questions on the fine of that as well. Excellent job, Ravi. Next question. Does the person... sorry, there is a duplication of questions right here. Something is wrong. Okay. If in any return, statement, or other document required by or for the purpose of any of the provisions of the LLP Act, a person makes a statement which is fall in any material particular. So if in a particular material, a person is making for the purpose of statement, return, or other document, right? We didn't deal with statement, return, or other document. We dealt with different aspects before. If the person is in an LLP making a false statement, which he knows to be false, for these required fields, what shall his punishment be? Is it punishment of imprisonment up to 2 years and fine between 1 to 10 lakh rupees? Is it punishment up to 5 years and fine between 1 to 5 lakh rupees? Is it punishment up to 2 years and fine from 1 to 5 lakh rupees? Or is it punishment up to 1 year only and fine for between 5 and 1 lakh rupees, so 1 to 5 lakh rupees? Which one of these is it? Is it 2, 5? Sorry, one of the options is meant to say 3. Is it 2, 5, 3, or 1 year? Imprisonment of 2, 5, 3, or 1 year, and then also fine between 1 to 5 lakh rupees. Okay, we think it is 2 years and fine between 1 to 5 lakh rupees. And that is correct. It is 2 years and fine of 1 to 5 lakh rupees because of Section 37. So if you know something is false and you make that false statement for a particular material, if you make that false statement for a particular material, or another thing, if you even omit to provide a material fact, and this is material, this needs to be disclosed, this needs to be provided to the registrar so that he performs his functions of gathering information, the punishment is up to 2 years and then also fine between 1 to 5 lakh rupees. Who among the following may destroy any document filed or registered with him in physical form or in electronic form in accordance with such rules as may be prescribed? So destruction of material. Can the registrar do it, partners do it, LLP do it, or can the court only itself do it? So destruction of material. Who can do it? Physical or electronic material? Court, registrar, partner, LLP. Any guesses? Ravi thinks it's LLP. Ravi thinks it's the registrar. Medha thinks it's the registrar. We are correct. Section 40 is empowering the registrar to make any such destructions of material. Next question. Section 41 of the LLP 2008 provides for which of the following? Does it provide for, now 41, power of registrar to strike defunct LLP off register? So if a LLP is defunct, the registrar has the power to strike it. Is that what section 41 is dealing with? Is it providing for the power of making rules? Who has the power to make rules? Is it for the enforcement of duty to make returns, or is it for rules for winding up and dissolution? Now, Ravi thinks it is for enforcement of duty to make returns. Ravi thinks it deals with enforcement. Aditya thinks it's power of a registrar to strike defunct LLPs off the register. Who else is making? Okay, Aditya also thinks it's 3. I have started the timer. What do the rest of us think? We are just at the last few questions. Let's give it our best shot. And that is correct. 41 deals with enforcement of duty to make returns. So the enforcement of an LLP, enforcing the duty of the LLP to make returns. That is what it deals with, and other aspects. Which among the following section has been omitted by the LLP Amendment Act of 2021? Come on, guys. Let's show our presence of mind. Is it section 80, 81, 79, or 78? I'm not going to give you more time. I have started the timer. This is something we should know already. What has been taken off the act? Anonymous thinking it's 81, 81. Excellent, 81, just like I told you. It dealt with transitional provisions, but it was taken off by the 2021 Amendment Act of the LLP Act. Which section provides for general penalties? There is a section on general penalties inside the LLP Act. Which section deals with it? Is it 72? Is it 27? Is it 74? Or is it section 47? The timer has begun. Come on, guys. Guesses. General penalties are covered under section 74 of the Act. Correct, Ravi? Again, it was substituted by the 2021 Act as well. There were several changes made within it, and it provides for general penalties under the LLP Act. Every partner acts as an agent for which of the following? The LLP itself, the other partners, the registrar, or the LLP agreement? Now, a twist here. Does a partner act as an agent for LLP, or the LLP agreement, or the other partners, or the registrar? Which of these can it act as an? Okay, so Ravi thinks it's LLP, not the LLP agreement. Only the LLP, not the LLP agreement. Excellent. Good job, guys. Don't get confused. Not the LLP agreement. We discussed this before. Just the LLP, section 26. He, again, the person who's a partner of the LLP, he is an agent for the purpose of the LLP, not the agreement, for the purpose of the LLP, not for the partners, not for the LLP agreement. So don't get confused. If you see options LLP agreement and LLP, don't be hasty and check for option 4. Where after a partner's death? Okay, a long-winded sentence. Let's pay attention to it. Let's read it all through. Yes, Ravi, that's correct. Agent of LLP, not of others. Not of LLP agreement, just the LLP as an entity, as a body corporate in itself. That is what a partner is an agent of. Where after a partner's death, the business is continued in the same limited liability partnership name. So the partner has died, but the business is still continued by the other partners. The continued use of that name or of the deceased partner's name as a part thereof shall not of itself make his legal representative or his estate liable for any act of the limited liability partnership done after his death. So, does the onus of acts that are done after his death in his name as the LLP fall on the person's legal representatives or his estate or not? Determine the nature of this statement. Is the given statement true? Is the given statement false? Is the given statement only partly false? Or can we not determine whether the statement is right or incorrect, right or wrong, because there is no tacit provision that speaks about it in the LLP? What do you guys think? So the partner has died. Business is continuing in his name under the LLP name, and the continued use of that name is happening. But his legal representatives, the use of his name simply in the actions does not make his legal representatives liable for his activities. Which of the following options will be correct? Do you think this statement is correct? Do you think it's incorrect? Do you think that the LLP Act does not elaborate on it so we cannot make a statement, or do you think it's only partly false and it might be partly correct? Pratibha thinks it's true. With that, I'm starting the timer. Ravi, Tanya, Govind, the statement is true. Section 29(2) specifically provides for it that even after the person's death, the name, just the use of the name in itself, does not make the estate liable for the actions, because the person himself is deceased and the executive action is done by some other people. Section 30 of the LLP Act 2008 provides for which of the following? Does it deal with whistleblowing provisions, limited liability in case of fraud, unlimited liability in case of fraud, or does it deal with annual return? Ravi thinks for 30 deals with holding out, which is not one of the options. Okay, limited liability in case of fraud. Yes, Ravi. Be very patient with the questions. Read them well. The correct option is unlimited liability in case of fraud. So do you see, Ravi, what quick reading is doing? Just be very purposeful in reading. The two options I'll show you again. The two options are limited, unlimited. This is why I'm putting slightly different options, and this is why I'm repeating the same concept twice in some of the questions, so that there is a possibility of getting confused. So make sure you're reading the questions properly. Unlimited liability, case of fraud. Next question. The dash of contribution of each partner shall be accounted for and disclosed in the accounts of the limited liability partnership in the manner as may be prescribed. What? The value of the contribution of each partner is accounted in this manner. Is the monetary value? Does the act use the words monetary value? Does the act use the words account value? Or does the act use the words the money of contribution? What words does the act use? So the partner that who's making these contributions, and the contribution will be accounted in a manner that the LLP provides for. But what value? Monetary, just value, account value, or money? Anonymous thinks we are dealing with money, the term money. It is monetary value. Section 32(2) states that the monetary value of the contribution, not account value, not any other value. Yes, to monetary value. Next question. Again, very, very important. Pay attention. The obligation of a partner to contribute money or other property or other benefit or to perform services for a limited liability partnership dash be as per the limited liability partnership agreement. What word is used here? Words signify a lot. We know as students of law what the importance of words is. Does the act use the word shall? Does the act use the word may? Does the act use the word shall not? Or does the act use the word may not? Ravi thinks it's relevant under section 33 and the word used is shall. Meda thinks it's shall. And the correct option, of course, is shall. And Ravi is correct. This is 33 subsection 1. The obligation, it's in the nature of an obligation. The provision is in the nature of an obligation. So for an obligation, the words used are, of course, shall, but we are dealing with that the obligation, how it is determined, how it is dictated. This obligation is dictated as per the LLP agreement itself. The agreement decided upon between the partners. While trying an offense under the LLP Act, a special court may also try an offense other than an offense under the LLP Act with which the accused may, under the dash, be charged at the same trial. So the LLP Act is the special court under the LLP Act is trying an offense. It may also try a parallel offense, another offense, where under IPC, under CRPC, under CPC, under evidence, where would the person again be charged? What do we think? Anonymous thinking it is CRPC. What are the other guesses? What are the act finds and creeps its way into this act? We are correct, it is CRPC, and the relevant section here is 67B. So if a case is being tried under the special court for an activity or an offense under the LLP Act, what can also be done? The person can be charged at the same trial under the provisions of the CRPC. In which among the following cases can summary trials be done? Summary trials. Offenses under LLP with punishment for a term not exceeding 7 years. Offenses under LLP for punishment not exceeding 5 years of imprisonment. Offenses under LLP not exceeding imprisonment of 3 years. Or offenses under LLP not exceeding offenses imprisonment of 2 years. So is the extent of imprisonment up to 7 years, 5 years, 3 years, or 2 years, where summary trials can be done? 3, not exceeding 3 years. Meda also thinks offenses where the imprisonment is not exceeding 3 years. Excellent. Section 67B again, but in subsection 3. So notwithstanding anything in the CRPC, this works to the exclusion of CRPC. The special court may, if it thinks fit, try in a summary way any offense under this act which is punishable with imprisonment for a term not exceeding 3 years. Last few questions. Come on, guys. Where is Tanya? Where is Govind? Let's wake up. Last few questions. Let's give it all. We have finished 100 hefty questions. For a limited liability partnership to be incorporated, which of the following is required for an LLP to be incorporated? Do we need 2 or more persons who are associated for carrying on a lawful business with a view to profit? And do they need to subscribe their names in an incorporation form? Do we otherwise need an incorporation form to be filed in a manner and with a fee as is prescribed by the Registrar of State where the LLP is required to be situated? Do we need a statement by either an advocate, a CS, a chartered accountant, or a cost accountant that all the requirements of the LLP Act and all the rules have been complied with? Or do we need all of the above? What do we need for the incorporation of an LLP? The incorporation of an LLP, guys. Which of these is an essential for the incorporation of an LLP? I'm giving you a bit more to read. Meda thinks it's all of the above. We need everything. Let's start the timer. We are quite confident. And the correct answer is 4. We need all of the above. There is some error with the slides on my part. Sorry, guys. Next question. What does Section 29 deal with? Section 29, what does it deal with? Does it deal with holding out? Does it deal with general penalties? Does it deal with extent of liability of partners? Or does it deal with none of the above? Does it deal with something else? 29 of the LLP Act. 29, we are looking at doctrine of holding out. Doctrine of holding out, and we are correct. Section 29 deals with extension of doctrine of holding out here as well. Next question. The obligation to contribute are referred to in which section of the Act? There is an obligation to contribute infused in the LLP Act. Sorry, guys, I'm a bit unwell. Is it section 33? Is it section 19? Is it section 12? Or is it section 17? We have Ravi thinking it's section 33. I have begun the timer for the rest of us. So obligation to contribute, that is correct. Section 33 deliberates upon the obligation to contribute. And let's move on to the next question. Which section deals with the partner's transferable interests? The section dealing with partner's transferable interests is section 24. Is it section 12? Is it section 17? Or is it none of these? What do we think? Ravi, Adidivya, Meda, Anonymous. Let's see. Where are the rest of us? Which section deals with partners' transferable interests? I'll give us a few more seconds because we only have one question after this. Okay, Anonymous going for the none of these options. So what do you think is the section on partners' transferable interests instead, if it is not any of these? If it's not 24, 12, or 17, what must it be? It is 42. We are right. 42 deals with the transferability of interest, and it states that the rights of a partner to share of profits and losses of the LLP and to receive distributions are transferable either wholly or they are transferable in part. Next question. Can a firm be appointed as an inspector under the LLP? Appointment of a firm as an inspector. It may be done, it may not be done, it shall not be done, or it cannot be determined. Is the Act silent on it and thus it cannot be determined? What do we think? The appointment of a firm as an inspector. Come on, guys. So we know the significance of the terms may and shall. We know the distinct. We have Sonal. Sonal, did you just join us? We are on the very last question. I hope you go through the quiz again. It shall not be determined, Sonal thinks. I'm starting the timer for the rest of us here. Firm inspector, and that is correct. Section 45 categorically excludes firms, body corporates, or other associations from being appointed as inspectors. So that was all for your quiz right here. I hope you have gone through some concepts. I hope there are certain elements that have been clarified in your minds. I hope there are certain confusions that have erupted in your minds that you will go back to discuss with me, that you will go back to your quizzes, your MCQs, that is to say, your mocks and your repositories, your PYQs, and everything we provide, and your bare acts essentially also, that you will go back to and revisit the concepts. Again, very easy to understand the entire act if you understand the company law, if you understand partnership. Very, easy, very buttery soft to apply to your mind if you understand those aspects. Not a lot of changes, just that you have to remember what things contribute towards the elements of an LLP, who can be appointed, who can be a designated partner, who can be a partner, and just a few tiny concepts that need clearing if there is any confusion. So just let me know. Again, I'm accessible on your WhatsApp, and again, I would urge you to take up all of the mocks, take up all of the marathons, take up all of the quizzes, and make sure you're benefiting from this. Don't leave any reason for you to look back with resentment on the day of the prelims, that I wish I had gotten confused by this concept before and clarified it with the people helping me at Losico. So just make sure you're not one of the people who are thinking this on the day of the examination. Thank you, Ravi. Thank you so much. I hope you guys had a great time here. I hope you'll come back for marathons and sessions and quizzes and the mocks as well in the next few days. Don't miss out at all. And take care. Have a good night. I'm sorry this stretched a bit too far, but we had a lot of questions to discuss. And again, any confusions at all, please reach out to me. I am readily available to help you out. Best of luck, and don't stop the Josh. You have to crack the DJS, and you will crack the DJS. Take care, everyone. Have a good night and prepare well. Bye bye.